Bismillah. My name is Ahmad Al-Qari bin Ahmad Rum. My matrix number is 077457, and today I gonna tell you about the introduction of the territorial and maritime dispute between Nicaragua and Honduras in the Caribbean Sea. The dispute between Nicaragua and Honduras over territory and maritime boundaries is very complicated but very important. Both countries claim certain waters and islands in the Caribbean Sea, which has led to these agreements. This area is rich in resources and plays a key role in the lives of many people. Local communities rely on fishing for food and income, and there may also be valuable oil and gas under the sea, making the stakes even higher. The conflict is about more than just land and water. It also involves international law. The United Nations Convention on the Law of the Sea helps countries decide how to share ocean resources fairly. Both Nicaragua and Honduras have overlapping claims to fishing rights and areas that could be explored for oil. Finding a peaceful solution is crucial to keeping the region stable, ensuring fair sharing of resources and protecting the environment. To do this, both countries will need to engage in diplomatic talks, work together, and possibly use international mediation to build trust. Cooperation can lead to agreements that benefit everyone. Solving this dispute thoughtfully and peacefully will create long-term prosperity and security for the entire region.
Bismillahirrahmanirrahim. My name is Muhammad Zuhair Naim bin Magdani, and my matric number is 077840. And next I will talk about the history and background. So after gaining the independence from Spain in 1821, Nicaragua and Honduras inherited poorly defined colonial era borders, leading to overlapping territorial claims in the Caribbean. In the 20th century, dispute intensified as both nations sought exclusive economic zone or EEZ to exploit offshore resources like oil, natural gas and fishes. 1999 bilateral treaty attempted to address these issues but was criticized for its vagueness, particularly regarding island sovereignty and maritime boundaries. That same year, Nicaragua brought the dispute to the ICJ or International Court of Justice, alleging Honduras infringed on its maritime rights and seeking clarity of the ownership of the island like Bobble Cay and Savannah Cay Island, as well as the delimitation of maritime boundaries.
Assalamualaikum warahmatullahi wabarakatuh. My name is Fakrullah Fitri, and I'm going to present to you a fact of the case about territorial and maritime dispute between Nicaragua and Honduras in the Caribbean Sea. The party involved is Nicaragua and Honduras. The dispute happened over maritime borders in the Caribbean Sea. The disputed areas included the Triangle Maritime Zone claimed by both countries, including certain islands such as Bobble Cay and Savannah Cay. The origin of the dispute compromised on colonial-era treaties because of unclear proclaimed maritime boundary. This agreement of misinterpretation of historical agreements such as the 1928 Esguerra-Bárcenas Treaty. The jurisdiction relied on international law, including the United Nations Convention on the Law of the Sea, customary law, and historical agreements. Both countries accepted ICJ jurisdiction to address the maritime boundary dispute, enhancing the court's authority over the case.
Hello, my name is Muhammad Fauzan bin Ahmad Lutfi. My matric number is 079121. And now, let's move to the parties' argument. First, there's two parties in this case, which is Honduras and Nicaragua. Honduras argue that they rely on the uti possidetis juris, which is the principle preserved during the colonial time. And then Honduras also argue that it has the long-standing administrative over the disputed areas, including the cays and banks. The third argument of Honduras is it claims that the 50th parallel was recognized by the regional agreement and by third parties to tacit the recognition of Nicaragua claims. The last argument of Honduras is Honduras claims that the strict principle of equidistance by the Nicaragua is not appropriate given the specific of historical context of Honduras. Now we are moving to the Nicaragua arguments. The first, Nicaragua argued that all the maritime boundaries should be using the equidistance method in order to ensure the relevant circumstances and ensure equity. Nicaragua also dismissed the sovereignty of Honduras by saying that the using of uti possederis juris is irrelevant. And the third point is Nicaragua also claims the sovereignty over the disputed areas, including the case and banks, that they argue that the area was closer to Nicaragua mainland. The last is Nicaragua refuted the argument that it had tacitly recognized the 50th parallel as a boundary. Thank you.
Hi, Assalamualaikum. My name is Muhammad Ibrahim Muhammad Amade. My matrix number is 076804. Today I will discuss the court judgment and the arbitrary term that's contained in the case of Nicaragua and Honduras in territorial dispute. The ICJ awarded the Honduras sovereignties over the Bombay K, Savannah K, Port Royal K, and the South K. The court reject Honduras' argument that the uti possidetis juris principle that's concluded there was no tacit agreements. Therefore, the maritime boundary needed to be limited de novo. The court stated that the Cape Gracias a Dios was unfairly to demarcate the maritime boundary, considering its geographical factors. The ICJ applied the bisector methods, which are involving dividing the angle formed by linear approximations of the relevant coastline of the two states. While the arbitrary terms in this case is the court reflected on the 1906 arbitral award by the King of Spain and its implication for the land boundary. While this award provided maritime delimitations, the ICJ stated its broader historical significance was not essential to the maritime delimitations.
My name is Muhammad Karikuan bin Nazri. My matric number is 077040. And now I will explain about the public opinion of this case from both Nicaragua and Honduras. Okay, first, from Nicaraguan side, many Nicaraguans are satisfied with the ruling made by the ICJ because some cases were awarded to Honduras. Even though they are unhappy with the ruling, there was some bit of pride in this decision made by the government to pursue the case through peaceful and rather than escalating tensions. And the fishermen and the coastal community in Nicaragua feel worried over the implication for fishing rights and access to their marine resources. And next, now we move to the public opinion of the Honduras people. Hondurans celebrate the ICJ's ruling as a diplomatic victory, especially regarding to the award of the disputed keys to their country. The outcome from the ICJ strengthened the sense of trust in the international institution and the neutrality of the legal dispute resolution procedures. And the coastal communities and the business were very optimistic about the economic potential because of the increase of the control over the marine resources.
Assalamualaikum warahmatullahi taala wabarakatuh. My name is Muhammad Amar bin Ahmad Sahiri. My metric number is 078525. The territorial and maritime disputes between Nicaragua and Honduras is a very complex issue rooted in historical claims, colonial legacies, and the evolving of the international law. For decades, these two countries have been trying to assert their sovereignty over the maritime zones, the islands, and the resources that can be gathered in the region. This highlighted the importance of national security, economic development, and regional stability. This case was brought to the International Court of Justice (ICJ) in 1999. This highlighted the importance of peaceful resolution through legal frameworks rather than through conflict. In 2007, the ICJ issued a court ruling to fairly limit the maritime borders between the two countries. Although the two countries accepted the court ruling, conflicts still arise because of their different interpretations and through resources exploitation. This dispute highlighted the importance of diplomacy, international cooperation, and last but not least, the importance of international law itself. Thank you.